their jokes because lawyers don't think they're funny. Everybody else don't think they're jokes.
This is a lawyer jokes.
Oh, you kind of gonna make me eat my words, aren't you? Okay, I think we will reconvene. You might notice that Mr. Lepore had to leave us, and I've forgotten his excuse. If I remembered it, I'd tell you, but it was legitimate. Interstate Oil and Gas Commission. Oh, yeah, okay. All right, then. Ms. Murphy, what should we do next?
Chairman, I would suggest that we call the Marilex matter docket 150500158. It's a hearing matter or an enforcement hearing. Britta is the advocate on behalf of enforcement staff, and Mr. Zimsky is here on behalf of Marilex Resources. My understanding is that each party has an hour allocated for their opening, case in chief, cross-examination, and closing. So I will be managing the time. And with that, I would turn it over to the parties.
Mr. Chairman.
Each party has an hour,
Yes, sir.
and in addition to, you said, or the hour includes their...
Includes all of those things. And so obviously it's almost 4:00, and how you, Chairman and Commission, would like to have this enforcement matter. We can push on through this evening. We can reconvene tomorrow morning at an appropriate time.
Okay, why don't you all begin to think about that, and we'll go till whatever you want, whatever you're willing to go to. We get to be somewhere around 5:30. We'll ask you all whether we want to wrap it up, work through it, or reconvene tomorrow. We do have it noticed for tomorrow if we need to. Okay. Well, Commissioner Benton, I noticed you had your hand up.
Thank you. I would like to request to recuse myself from this hearing matter. Just in, again, the best interest, we work with Marilex on some other properties not specific to this, so I think it's probably in best interest to recuse myself.
Very well, thank you.
Thank you.
We still have a quorum. So we could say we don't need you, but that's not true. Okay. Ms. Beckstead, are you going to initiate or?
Yes.
Okay.
Good afternoon, Commissioners. Britta Beckstead, Counsel for Commission staff in this order finding violation hearing against Marilex Resources Incorporated. So why are we here today? Water is coming out of the Bradenhead annulus of a well. 12 Bradenhead tests were not performed on 4 coal bed methane wells. A separator stack did not have the required wildlife screen for over a year. Casing repairs were performed without allowing staff to approve them prior to them being performed. These violations are all linked by one thing. They occurred at wells operated by Marilex, an operator who has refused to abide by Commission requirements. Today, staff is requesting an order finding that Marilex violated Order 11285 and Rules 317E, 319B1, and 605B7, imposing a penalty of $100,100 and requiring Marilex to perform the annular flow remediation within 30 days of the entry of the order. Today, it is this Commission's task to determine, Nancy? Okay, there we go. Today, it is this Commission's task to determine whether the 12 Bradenhead tests were indeed performed, but the documentation was just not submitted, and if true, whether this should impact the penalty. 2, whether a lower penalty should be imposed for the violations of the federal 26-3 well. 3rd, whether the Rifle Walton 25-2 well was temporarily abandoned from November 7, 2014 to February 26, 2015. And lastly, whether the Commission has the authority to require the annular flow remediation at the Rifle Walton 25-2 well, and whether this requirement is arbitrary and capricious.
I'm sorry, Ms. Beckstead, would you restate the final?
Of course. whether the commission has the authority to require the annular flow remediation, which is additional cementing that staff is requiring to stop the water flow at the Rifle Walton 25-2 well, and whether this requirement is arbitrary and capricious. First, I'll address the violation of Order 11285 and the Bradenhead test at the Katie Eileen wells. Rule 10 of Order 11285, which was entered in 1990, requires that all wells capable of production, injection, or observation will be tested by the operator for pressure and flow, with results submitted to COGCC and other appropriate regulatory agencies on approved forms. The Commission's testing and documentation requirements are found in Rules 207B, 314, and 608E. The Katie Eileen wells are coal bed methane wells and therefore require Bradenhead tests every other year, with documentation submitted within 10 days after completion of the tests on a Form 17. There we go. Merrilex does not dispute that it did not timely submit and has still not submitted the required documentation for 12 of these Bradenhead tests for the years of 2009, 2011, and 2013 at the 4 Katie Eileen wells. Tests were performed in November of 2014, but there is a huge gap in our knowledge regarding what was happening at these wells in the intervening years. Today, you will hear Mr. O'Hare, Merrilex's president, testify that these tests were performed, but the results were simply not submitted due to the failure of a Merrilex employee. It is your task to determine first whether this testimony is credible, and then whether it should impact the penalty. If true, this was Merrilex's error. It is the operator's responsibility to oversee its employees, and this did not happen for a period of 5 years. Whether or not the tests were actually performed, this is also a violation of Commission orders and rules. Without documentation, staff and this Commission has no way of verifying compliance and ensuring that development is occurring responsibly. Merrilex argued in its pre-hearing statement that since 4 wells passed Bradenhead tests in November of 2014, you should assume there is no threat of environmental harm for the failure to perform the tests in the prior years. But what happens in the case where a well isn't tested for 5 years and it has been leaking the entire time? Without enforcement of this order, there is far less incentive for operators to prevent this from happening. And until these tests were performed in 2014, we didn't know that wasn't happening here at these wells, which is indeed a threat. As a result, staff is requesting a $10,000 penalty for the violations at each of the 4 Katie Eileen wells. Turning now to the violations at the Federal 26-3 well. Merrilex does not dispute any of the facts supporting this violation, the violations of Rules 317E and 605B7. The purpose of Rule 317E is to protect hydrocarbon formations in groundwater. It is undisputed that Merrilex did not obtain prior approval before performing casing repair on the Federal 26-3 well. It is irrelevant whether this was the result of an internal miscommunication, as Merrilex alleges. Again, it is your task to determine whether we hold operators to a standard where they're responsible for their own administrative errors. Staff can only do its job when operators provide the required information. As a result, staff is requesting a $2,500 penalty for this violation in the hope that it does not happen again. Rule 605B7 requires all stacks, vents, or other openings on combustion equipment to be equipped with screens or other appropriate equipment to prevent entry by wildlife. It is also undisputed that the separator did not have a screen at the Federal 26-3 well during the August 5th, 2013 and November 7th, 2014 inspections. It appears from Merrilex's pre-hearing statement and recommended order that Merrilex does not dispute this violation or the $10,000 penalty that staff is seeking for it. The majority of the party's time here today will likely be spent on the Rule 319B1 violation and the required remediation at the Rifle Walton 25-2 well. Rule 319B requires operators to obtain prior approval and perform a successful MIT prior to temporarily abandoning a well. A temporarily abandoned well is defined in the 100 series as a well which is incapable of production or injection without the addition of one or more pieces of wellhead or other equipment, including valves, tubing, rods, pumps, heater treaters, separators, dehydrators, compressors, piping, or tanks. Merrilex does not dispute that it did not obtain prior approval or perform a successful MIT. Don't want to ruin it yet. Prior to temporarily abandoning the well and removing the separator from the site. Merrilex also does not dispute that the separator was not on the location from November 7th at the November 7th, 2014 inspection or the December 8th, 2014 inspection. From November 7th to February 26, 2015, Merrilex has provided no evidence that the separator was returned and hooked up to the site. In its pre-hearing statement, staff alleged that this violation continued until April 1st, 2015, when an MIT was finally successfully performed on the well. However, staff recently learned that the separator was returned to the site and hooked up on February 26, 2014, and has adjusted the penalty calculation accordingly. This reduces that penalty for this violation by approximately $2,100. Oh, I'll let you do this. Thanks. Merrilex contests that the well was never temporarily abandoned because the well was still capable of flowing without a separator. This is not the standard of a temporarily abandoned well under Commission rules. Flowing or venting gas is not the same as producing. If you can't put the gas into a sales line, this does not qualify as producing under Commission rules. Merrilex's assertion cannot overcome the plain language of this rule. It is your task to determine whether this well qualified as temporarily abandoned from November 7, 2014 to February 26, 2015. Staff calculated this penalty under the new act because it began after the effective date of the amendments. And staff is requesting a penalty of $47,600 for this penalty, which lasted for 111 days. Turning to the second issue at the Rifle Walton 25-2 well, the issue of the annular flow remediation. The Rifle Walton 25-2 well is located near East Divide Creek and several water wells completed to the Wasatch Formation, as shown here on Exhibit 2. Pressurized water is flowing out of the Bradenhead annulus of this well, and Merrilex has refused to perform the cement remediation necessary to stop this issue. As you can see from the wellbore diagram on the next slide, which is Exhibit 3, if a water-bearing formation exists anywhere below 309 feet, which is where the surface casing ends, there is a direct path to the annulus and the surface until Merrilex undertakes the remediation.
Let's just take a moment, whatever.
All right.
Sorry.
Thanks. Okay. Greg Berger, COGCC Northwest engineer, will testify to his assessment regarding the possible causes and consequences of this water flow, including that this flow could be depleting the aquifer or recharging the aquifer from a deeper source that could contain contaminants. Order 1107, which is staff's Exhibit 4, gives staff the authority to impose remediation requirements if there is a continuous flow of liquid at any pressure. Due to the fact that staff recently learned that the separator was returned to the site and the bridge plug was removed from the well after the April 1st, 2015 MIT, staff is no longer alleging that the well continues to be temporarily abandoned for the purposes of requiring the remediation today. Instead, staff will show that this commission has authority to require the remediation regardless of well status. First, the Act gives the Commission the broad authority to regulate the drilling, plugging, and producing of wells and all other operations for the production of oil and gas. Under Order 1107, if there is a continuous flow of liquid, operators are supposed to propose procedures to remedy such situations, which are subject to staff approval, and then implement them. The July 8, 2010 notice to operators summarizes these order requirements. This notice was added to staff's exhibits as Exhibit 14. The notice states that venting or flowing the water tank may be allowed as an interim step while the operator develops a proposed remediation procedure. This notice specifies that this is not a permanent solution, especially where significant water volumes are observed. Mr. Berger will testify that staff never received a proposed cement remediation procedure from Marilex. As a result, staff developed its own procedure that is designed to eliminate the flow of the water to the surface. Other commission rules, such as Rules 208, 209, and 317E, further support the commission's authority to require this remediation. Rule 208 states that the commission shall require correction of any condition that is likely to cause pollution. Rule 209 states that special precautions shall be taken in the drilling and abandoning of wells to guard against any loss of artesian water from the stratum in which it occurs and contamination of fresh water by objectionable water, oil, or gas. Rule 317E states that the casing and cement program for each well must prevent oil, gas, and water from migrating from one formation to another behind the casing, which is precisely what is occurring here. Marilex will argue that because the Rifle Walton 25-2 well is not being actively drilled or deepened, Rule 317 should not apply. But surely the requirement to protect groundwater exists even after the well has been drilled. It is your task to determine whether the Act, Order 1107, and Commission rules support a finding that this Commission has the authority to require this remediation. You will hear a lot of talk today regarding what occurred at this well in 2011. Mr. Berger will testify that staff first became aware of these issues in 2011 after receiving Braden head test results that showed abnormal pressures. He will also testify that staff allowed Marilex to attempt to alleviate the pressure by allowing water to flow to a tank, and required Marilex to test the water that was coming out of the Braden head. Marilex's attempt to alleviate the pressure was unsuccessful, as Mr. Berger witnessed at the 2014 inspections, and pressurized water is still making its way up the annulus. Marilex will argue that based on the 2011 test results, there has been no environmental impact, and therefore the Commission cannot require this remediation. Staff is not currently alleging that there is an actual environmental impact. What staff is alleging is that this is an ongoing isolation issue that needs to be fixed. This Commission's mandate is to ensure that the environment and public welfare are protected during oil and gas operations, and protection is most successful when it is forward-looking and preventative. Marilex will also argue that staff's requested remediation is arbitrary and capricious. The standard of arbitrary and capricious requires staff to have examined the relevant data and articulated a satisfactory explanation for its action, including a rational connection between the facts found and the choice made. Staff has provided reasoning and facts supporting the requirement for this remediation in the record, and more will be added to that record today. In conclusion, staff will show that it is more likely than not that these violations occurred. And in order to do this, first, staff will prove why this Commission should doubt that the Braden head tests were indeed performed, and demonstrate that the documentation of the tests is a Commission requirement on par with doing the tests themselves. Second, staff will prove that Marilex has provided no evidence supporting the reduction of the violations at the Federal 26-3 well. And lastly, staff will prove that the Rifle Walton 25-2 well was temporarily abandoned from November 7, 2014 to February 26, 2015, that the Commission has multiple sources of authority to require the remediation, and that this requirement is well-reasoned and supported by the available evidence. Thank you.
Okay, Mr. Zemsky.
Good afternoon. William Zemsky on behalf of Marilex. Good afternoon. William Zemsky on behalf of Marilex Resources. I'm here with Mr. O'Hara, the president of Marilex, to present our case. Before beginning, we had requested several hours to present our case. The hearing officer has restricted us, both of us, to 1 hour apiece, and we think that's a little bit, I've prepared a truncated presentation, but we believe that infringes upon our rights to defend in this proceeding. I think Ms. Eksted's opening was 15 minutes, and I thought it was concise. I don't think she was rambling or anything, but it was 15 minutes just for her opening. So I'm going to try to be as truncated as I can, but I do want to state for the record that we oppose the limited amount of time we're given here today.
Duly noted.
Thank you. Braden head testing, Mr. O'Hare is going to testify that he did the testing. He's also going to testify it was his fault that it didn't get reported. He's not throwing any employee under the bus. He's the president. He's responsible. He takes full responsibility for the reports not getting submitted to the commission. He's also going to testify he had occasionally, on a random basis, opened a Braden head valve to just make sure it was okay, and he did that over the course of last. Since 2007, since these things had to be tested, and he actually did that, and he maintained it. No repairs were ever made to any of these Braden head valves, Braden heads, and therefore there was no. The fact that they passed in November of 2014 establishes that these Braden heads were in good working order, and that there was no problem with any of these wells. And I'll skip right to the Rifle Walton. Our legal argument is that it was not temporarily abandoned because it was capable of production. And that's what the rule says. Is it capable of production? There was not a separator there. There's a difference between producing and selling. And even on the commission's own forms, there's a column for production, venting, used at the well site, and sale. And usually the sale is less than what was produced. This is wet gas. They could actually run it for half an hour and put that in the pipeline before the water started coming up. They could run certain generators on site, so it was capable of production without the separator. And finally, right now, the commission had approved in 2011 a way to handle the water that was flowing up. This is fresh water, very low, totally dissolved solids. It's basically almost drinking water, not tested for any type of biologicals, but for TDS, it is basically better than some municipal drinking water. The system is in place. It's containing the water. The water is being put into an evaporation pond, or was. Now it's being disposed of. So there is no environmental harm. And we also believe that the remediation that is currently in place is sufficient to address any concerns about this well. And we will question Mr. Berger about the efficacy of his proposal and whether that will actually address this problem, or whether he's making certain assumptions that cannot be established, more likely than not, or even beyond a reasonable doubt. And we'll also present evidence about the economics of this. We have a system in place that's taking care of the water. No water is being spilled out. The economics of having to do this remediation, 3 different cement squeezes, would make this well uneconomical and force plugging and abandoning. And that's the end. And how much time do I have left?
I think you have about 55.
Thank you.
Okay. Mr. Matter will universally swear all witnesses. Assuming there are some.
Everyone, please raise your hand if you're going to be a witness. Do you swear or affirm under penalty of perjury that the witness or the testimony you're about to provide today is truthful and accurate?
I do.
Thank you.
Okay, thank you. Ms. Beckstead.
Yes, staff would like to call Craig Berger to the stand.
Good afternoon. Is that loud enough?
You don't mind, you keep talking up.
Okay.
Mr. Berger, what is your position at the COGCC?
Engineer in the Northwest area.
And how long have you worked at the COGCC?
Over 2 years.
What degrees do you have?
I have a bachelor's of science in civil engineering from Washington State University and a master's degree in geotechnical geoenvironmental engineering from Colorado State University.
And what are your specialties?
Petroleum engineering, geotechnical engineering, and hydrogeology.
So first, I'm going to ask you about the Braden head testing violations of the Katie Eileen wells. Why are Braden head tests important?
Braden head tests are important because they give us an idea if there's a pressure in uncemented annulus on the backside of the well. It can be an indication of zonal isolation problems.
And why are they especially important for coal bed methane wells?
Yeah, they are especially important for coal bed methane wells because the way the coal bed methane is produced is the formation is dewatered, decreasing the pressure on the coal, which allows the gas to desorb. When you're dewatering the formations like that, there can be changes over time that need to be checked periodically.
And based on your review of the COGCC's records, did Merrilex file Braden head test reports for any of the Katie Eileen wells in 2009?
No.
How about in 2011?
No.
2013?
No.
Do you know if Merrilex performed the required test in 2009, 2011, or 2013?
Well, we have no way of knowing. There's no document submitted.
And why does the commission require operators to submit documentation demonstrating that these tests have been performed?
Well, the engineering staff reviews the documents and then selects wells that have high Braden head pressures to further evaluate and potentially require cement remediation.
And now turning to the casing repair approval and the wildlife screen at the federal 26-3 well. Why is Rule 317E important and staff's prior approval of casing repairs important?
It's important for staff to be able to review proposed casing repairs because we really need to ensure that zonal isolation is being provided, both to protect the public health, safety, and welfare, as well as to ensure that we have zonal isolation in the well and there aren't potentially hydrocarbon-bearing formations that could be subject to infiltration from potentially injurious waters moving from one formation to another.
Did Merrilex request prior approval for casing repair operations performed at the federal 26-3 well on October 28, 2014?
No.
Moving on to the failure to install wildlife screens on fired vessels, why is Rule 605B7 important?
Wildlife, especially birds, can land on a separator stack and become asphyxiated and die.
Did you inspect the federal 26-3 well on August 5, 2013?
Yes.
And what did you observe regarding the horizontal separator stack?
There was no wildlife screen present.
And in your inspection report, did you require Merrilex to install a screen?
Yes, that was put down as a corrective action.
Did you also request that Merrilex submit a Form 42 to staff when this corrective action was completed?
Yes.
Did you also inspect this well on November 7, 2014?
Yes.
What did you observe at that inspection?
There was still not a wildlife protection screen present on the separator stack.
Did you also inspect the well on December 8, 2014?
Yes.
And what did you observe regarding the separator stack?
At that time, a wildlife screen was present on the separator on location.
Did Merrilex provide any documentation to staff that this violation was corrected prior to December 8, 2014?
No.
Turning now to the Rifle Walton 25-2 well, and first the issue of temporarily abandoned status. Did you inspect the Rifle Walton 25-2 well on November 7, 2014?
Yes.
Was the well temporarily abandoned at the time of this inspection?
Yes, it was.
How do you know it was temporarily abandoned?
And there was no separator on the location, and there were no pipes connecting the well to the sales line.
I'm sorry, would you repeat that?
There was no separator on the location, and there were also no pipes, no flow lines connecting the wellhead to the sales line.
Could you describe the Commission's definition of temporarily abandoned in plain terms?
Basically, the definition, which was presented earlier, what it comes down to for the surface equipment is if a wrench needs to be turned, pipes need to be fitted or plumbed, then the well is temporarily abandoned.
Could the Rifle Walton 25-2 well have produced at the time of the inspection without turning a wrench?
No.
According to a review of COGCC's well records, was this well successfully tested for mechanical integrity prior to temporary abandonment?
No.
Did Marilex seek approval prior to temporarily abandoning the well?
No, they didn't.
Did you perform a follow-up inspection on the well on December 8, 2014?
Yes.
And was the well temporarily abandoned at the time of this inspection?
Yes, it was.
Was the separator still not on the site?
That's correct.
Did Marilex perform a mechanical integrity test on this well on January 20th, 2015?
Yes, they did.
Was it successful?
No.
What was the cause of the failed MIT?
They have informed us that they found holes in the casing, 5,600, 5,700 feet, fairly deep.
Did Marilex propose a repair procedure for these deep issues after the failed MIT?
Yes, they did.
And was the plan adequate?
No.
Did you communicate that to Marilex?
Yes.
Did you advise Marilex to call you to discuss the path forward?
Yes.
And did Marilex ever respond to your communication that the plan was inadequate?
Well, they didn't call me until about March 6th.
Did staff recently learn that the separator was returned to the site on February 26, 2015?
Yeah, I was recently going back through some documents and found that they had informed us that the separator was set back on the location on February 26th, I think.
Did Marilex perform a successful MIT on this well on April 1st, 2015?
Yes, they did.
Turning now to the annular flow remediation issue.
Just want the wellbore diagram?
Yeah.
Might be out of range there.
Yeah, technical issues. And Nancy, could you press Control L? Awesome, thank you. Could you describe the annular flow issue with reference to this wellbore diagram, which is staff's Exhibit 3?
Yeah, so what we have is we have an open annulus outside your steel casing down to a depth of about 5,120 feet, which is where a cement bond log indicates top of cement. So there's an open annulus here, and water is flowing out of this annulus out of the Braden head valve up at the top.
And what does Order 1107 require of operators in the area of the Rifle Walton 25-2 well?
That commission order requires annual Braden head testing for flow and pressure.
And what can staff require based on the results of these annual tests?
Based on the test results, staff can require remediation of the flow to significantly decrease the pressure and flow that's present.
Like the remediation that staff is requiring here based on the continued water flow?
Yes.
Did you review the Rifle Walton 25-2 well file and discuss prior enforcement events with other staff before issuing the NOAV for this well?
Yes.
Based on your review, did staff issue a prior NOAV for this well?
Yes, an NOAV was issued in 2010 for failure to perform the annual Braden head test on this well.
And after that NOAV was issued, did Marilex perform the required Braden head test?
Yes, the first Braden head test was performed in 2011.
And what did those test results show?
The test result showed a fairly high pressure, over 300 PSI in the Braden head. And due to the shallow surface casing here of only about 309 feet, that basically equates to a pressure at the surface casing shoe of greater than 1 PSI per foot. And what can happen at that point when that pressure gets too high right here is the formation can break down. And also during that test, the initial pressure was over 300 PSI on that Braden head. And basically, as soon as it opened, it began producing water fairly quickly.
Did staff require water sampling of the water coming out of the Braden head?
Yes.
And did staff calculate the total dissolved solids or TDS of this water sample after receiving that data?
Yes, we calculated a value of about 1,832 milligrams per liter total dissolved solids.
Nancy, could we advance one more? Two more? There we go. Why is this TDS calculation relevant?
Well, one of the parts of the definition of an underground source of drinking water is to have a total dissolved solids value of less than 10,000 milligrams per liter. Indicates it's somewhat fresh water.
And is this staff's TDS calculation, which is Exhibit 13?
Yes.
And how was the TDS calculated?
The TDS is calculated by basically summing the cations and the anions and performs this calculation. This is done in a spreadsheet in this example.
So does this water flow meet the requirements for an underground source of drinking water?
Based on the total dissolved solids, it does. There's some other questions about economics, how we don't basically know where this water is coming from, so we don't know how deep a water well would have to be. So there are some other things, but based on the total dissolved solids, it does.
And what other actions did staff require of Marilex in 2011?
Staff required Marilex to propose a remediation strategy to stop this annular flow.
Did staff also suggest that Marilex could run logs to better pinpoint the source of the water flow?
Yes, that was my supervisor was doing that in 2011. I wasn't with the commission at the time, but yes, I think he suggested running noise and temperature logs or other types of downhole instruments to determine where this actual source of water was.
Did Marilex perform any of these logs at that time?
No.
Did Marilex propose a cement remediation procedure in 2011?
No.
Did they suggest an alternative method of remediation?
Well, Marilex's proposal at the time was to basically open the Braden head valve and pipe it to a produced water tank and dispose of the water as E&P waste.
Did staff allow this alternative resolution?
Yes.
Why did staff close this issue, or why did staff allow this alternative resolution?
Well, at the time, we speculated that there could have just been some pressurized zone or a small lenticular sand of some sort that was producing this water, and that the flow and pressure would diminish if we vented it to a tank for a while.
And why did staff close this issue in 2011 and is now reopening it in 2015?
Well, after over 4 years of water flowing out of this annulus, and there's been no decrease in the volume, we think we sort of speculate now that it's probably a larger source of water down there.
What did you observe at the Braden head at the November 7, 2014 inspection?
The Braden head was being regulated at about 50 psi, and there was a continual flow of water.
If the Braden head issue had been a temporary buildup in pressure, what would the Braden head gauge have read?
Well, if the venting mitigation had been successful, it should have been close to zero.
So this reading indicates a continuing isolation issue.
Yes.
What did you observe at the Braden head at the December 8, 2014 inspection?
That inspection, I believe, was the time that we actually performed an annual Braden head test at the well. And we shut the Braden end in. It was being regulated at about 50 psi. One shut in, after about a minute, it built at 53 psi, which was the threshold we set as a do not exceed pressure for that Braden head. So at that time we opened it, and water began flowing continually out of the Braden head.
And how much water is flowing out of the Braden head?
The operator submitted annual reports to us, and they indicate that more than 7 barrels of water per day up to 13 barrels of water per day have been flowing out of the Braden head.
Could you describe the Rifle Walton 25-2 well location as shown in Exhibit 2? Nancy, would you mind going back one?
Yeah. Okay, so here, this little red dot is the Rifle Walton 25-2. These blue dots are water wells shown on the mapping system, although this one was not drilled. But there's right east Divide Creek Road, and then this is East Divide Creek Valley coming down this way, flows down to the north. There are several water wells in the area. that are producing water for domestic use out of the Wasatch Formation.
You happen to know, you happen to know the TDS in any of those?
I don't. There hasn't been a lot of sampling out there. Although one of these wells was sampled in 2010 or 2011.
Is it likely that the flow of water coming out of the Braden Head is from one of these formations?
Well, if you go back to the wellbore diagram, yeah, we just don't know at this point. You know, the water could be flowing all the way from somewhere in the Mesa Verde Formation up this annulus, or it could be coming from closer to the surface casing shoe. But we just don't know. There's Upper Wasatch is sort of what the geologists call the formation where the most of the domestic water would come from in this area. But we do not know if the water is coming from the Mesa Verde or the Wasatch.
Could you describe the potential issues that the continued flow of water presents?
Well, if the water is coming from the Upper Wasatch, then it could potentially be depleting an aquifer that people are using and have water rights for. If it's coming from the lower formations, it could have contaminants that could potentially impact the upper formation.
And how could the casing have mechanical integrity after passing the MIT, but the wellbore itself still lack integrity?
Well, the steel casing is what's tested during the mechanical integrity test at the surface. It does not test the annulus or the surface casing. So the Braden Head test is one of the tests that's performed to give an indication of additional integrity of the well.
And how could the deep casing leak that Merrilex repaired in March potentially impact the annular flow?
Well, the deep casing leak, we don't know what the top of cement was before the casing repair because there was not a cement bond log performed on this well until after the deep casing repair, which was around 56 or 5,700. So it is possible that this cement top was a result of the deep casing repair, and there was some casing hydrocarbon pressure or gas pressure leaking from the steel casing into the annulus.
What did the cement bond log that Merrilex submitted to the commission on April 1st, 2015 demonstrate?
That cement bond log showed the top of cement at about 5,120 feet, well below the Mesa Verde top formation. So there is not isolation between the Mesa Verde and Wasatch Formation in this well.
And can you explain using Exhibit 3 what staff is requiring for the remediation and why staff chose specifically those intervals for the cement?
Based on the information we have, we suggested about placing 100 feet of annular cement in the well, in the annulus here for somewhere around the Mesa Verde, 2,500, 2,600 feet to provide isolation between those formations. And then based on some review of induction logs and neutron logs, we also suggested providing cement in the annulus from about 900 to 800 feet to sort of try to isolate some lower water-bearing sands in the Wasatch from the upper portion of the Wasatch, which is used for drinking water. And we also suggested 400 feet of cement in the annulus from 400 feet to the surface to remediate past areas where there could have been surface breakdown due to the high pressure and to protect the water wells in the area.
Could staff have outlined these specific requirements prior to receiving the cement bond log?
No, we need a cement bond log because you can't place cement in the annulus, or it's more difficult if you're placing below cement.
If this was a new well, what would engineering require as far as cementing?
In this particular area in the Piance, we're currently requiring a fully cemented annulus or cement in the annulus up to 200 feet above the surface casing shoe. And we're also requiring much deeper surface casings on the order of 1,000 feet or deeper in this area.
Would staff require cementing to stop the flow of water if Merrilex was to produce the well?
Yes.
How about if Merrilex was to plug and abandon the well?
Yes.
So this is an unavoidable cost.
Yes, that's right.
Did staff require Marilex to perform the remediation, the annular flow remediation, at the same time that the downhole casing repairs needed to occur?
Yes, when Marilex asked permission to repair their downhole casing leak with 10 sacks of cement, we responded that that wasn't adequate and they needed to address the annular flow.
Would it have cost less money to have done the annular flow remediation at the same time as the casing repair than if the annular flow remediation was performed today?
Yes, they would have avoided an additional mobilization charge of all the equipment required for these type of operations, and they might have already had tubing in the hole or not needed to put additional tubing in the hole.
Are you aware of wells with similar issues that have been repaired?
Yes, there are wells in the area. I know at least 2 in the last year and a half where the operator has had some flow through the Braden head, and they have voluntarily remediated those with cement squeezes.
Nothing further from staff at this time.
Mr. Zemsky, do you have any questions for this witness?
Yes.
What do we call that?
Pardon?
Cross.
Cross-examination? Yes.
Okay, thank you.
Question.
Thank you. Good afternoon, Mr. Berger. Bill Zimsky on behalf of Marilex.
Good afternoon.
You indicated that a temporarily abandoned well was defined such that it can't produce without turning a wrench. Do you remember that?
Yeah, that's one way to think about it.
And that's your definition? Are there words to that effect in the commission rules for the definition?
Well, the definition was up on the screen earlier.
And the definition talks about, and I'll quote it from the 100 series, a well which is incapable of production or injection without the addition of one or more pieces of wellhead, and separators was highlighted. Do you recall that?
Yes.
And to your knowledge, can the Rifle 25-2 well produce gas but not sell it without a separator?
Yes.
In talking about where the water is coming from, I wrote a couple notes. Would it be accurate to say you don't know where the water is coming from?
Yes.
You're speculating now where the water is coming from?
No, not speculating. We don't know.
You don't know.
Yeah,
Okay, so you're not even speculating where it's coming from.
correct.
Now the water, there's no indication when, I guess you weren't speculating, I don't know what to call it, but you were indicating one reason why you wanted to have them squeeze cement down around 2,500 feet was that maybe there was some communication, maybe there's some water getting in the annulus in one of those formations at that depth.
Yes, that's possible.
But the TDS doesn't, or the water well testing doesn't indicate any type of water that's contaminated with hydrocarbons. Is that correct?
That's not correct.
And how's that incorrect?
Well, we have a sample that we didn't submit in evidence that indicates that the Braden head fluid coming out of the Braden head of this well had some benzene in it.
And could that be from an organic source?
I don't know.
It could be, in other words.
Yes.
Now, did Mr. O'Hare contact you about trying to work with you about the remediation. Do you recall the exchange of emails that you had with him?
Yes, there were some email exchanges, yes.
And well, let me go back. Back in 2011, the commission required Merrilex to undertake certain things with respect to the water flow from this well, correct?
Yes.
To your knowledge, has Merrilex followed those recommendations and
Yes.
requirements?
Yes, they have.
And there's no water flowing onto the surface around the wellhead, correct?
We have not observed that, no.
And is it possible that your cement squeeze remediations might not resolve this issue?
It is possible, yes.
Is it also possible that they could do the squeeze and the water that's flowing may manifest itself on the surface, on the well side or elsewhere? Is that possible?
No, I believe the procedure we gave is sufficiently conservative where that would not happen.
Is it possible that the water, if the water is traveling along a shallow part of underground, that it could, if it can't get up between the surface casing and the production casing, come up someplace else?
Well, naturally, yes. Yes.
And you're worried about now this TDS, you're worried that it may affect water rights of people that have water rights in the area?
Yes, that's a potential concern.
And currently you're requiring Merrilex to dispose of this as E&P waste?
Yes.
But the total dissolved solids are not, you indicates fresh water, correct?
Yes, by that underground drinking water definition.
So could, instead of disposing of this as an E&P waste, could instead, to address your concerns, could they recirculate this water such that it gets back into the ground?
No.
And that's because?
Well, there are rules against that.
Okay, but the TD, this is fresh water that's coming up. If there was spring water coming up on the well site, would they be able to divert that water away off of the well site?
From a natural spring, yes.
Could this be coming from a natural spring?
Yes, but it's not. It's coming from the wellbore.
But it's coming from someplace, and then it's coming up the wellbore, correct?
Yes.
So it could be a spring that's manifesting itself at the wellbore.
No, I don't think so.
You don't think so?
No.
Is it possible?
No, I mean, once it's coming out of the wellbore, it's considered a E&P waste. And so it's no longer a natural spring.
Okay, and, but, so the only, but that water is water that is what you've classified as fresh water, correct?
Classifies as fresh water, yes.
Now, your proposal for these 3 different squeezes would entail putting a tool down the hole and creating down the production casing and creating basically 4 holes in the production casing, squeezing it, moving up, doing the same thing, squeezing it, moving it up, doing the same thing, squeezing it? Is that a good summary of what would happen?
Yes, and when you say squeezing, you're referring to cement.
Yes.
Yes.
And so that would be 12 holes that you'd be putting into the production casing?
Yes.
In your opinion, could have a possible effect on the integrity of the production casing by putting these multiple holes at different levels? And you're going to squeeze cement, I understand that, but is that have any effect on the long-term integrity of the production casing?
Yes.
And that would be an adverse effect?
No, I don't agree with that.
But would have
It would have an effect, could be a positive effect, could be an adverse effect.
okay. And how could it be a positive effect to punch a hole in casing and then squeeze cement and have the cement there instead of steel?
Well, the steel will still be there. There will be holes in it, but there will be cement between the steel and the formation. And in some cases, depending on what the water behind that casing is, it can have a corrosive effect. So providing cement in the annuals could increase the integrity of the well.
And as far as the casing goes, is steel stronger than cement, correct?
Yes.
One moment. That's all the questions I have.
Okay, thank you. Do you have another witness?
Just a few follow-up for Mr. Berger.
Okay.
Mr. Berger, when was the water sample taken of this water that's expressing from the Brighton Head annulus taken?
I believe that was in 2011. It was our environmental group that did that sampling.
As far to your knowledge, have any other samples been taken since that time?
Not to my knowledge, no.
Also, is water flowing against a steel production casing damaging over a period of 4 years?
It's hard to say without knowing more about the water, how corrosive it might be.
No further questions.
Actually, if I could, it's a little irregular, but if I could ask a couple follow-up questions.
Well, we never do irregular. There, maybe not. If this provides valuable information,
I think it will. Mr. Berger, can you tell me, does it matter from an engineering perspective where the water is coming from?
It doesn't. The flow of water just needs to be stopped.
And if the squeeze as proposed by staff is not sufficient to stop that flow of water, will you propose an alternative that will stop the flow of water?
Yes, although we sort of prefer that the operator design their own cement remediation, and that is how the commission ordered can't remember the number, but that is how the commission order envisions it, is that the operator will design their own work.
And to your knowledge, is this well that we're talking about, is it a permitted water well or is it an oil and gas well?
No, this is an oil and gas well.
And just one last question. If I were unlucky enough to drill into a spring, some sort of artesian pressurized spring, would the COGCC make me cement that off? Would it make me, stop that flow of water somehow?
Yes, and somewhere in the rules, it does mention if artesian conditions are encountered, that the flow must be stopped.
Thank you.
In the rule, one just follow up, in the rule that you're referring to, or the order talking about remediation Does the remediation have to be reasonable?
I don't know if the word reasonable is used.
Well, I'll tell you, it's not used, but would you agree with me that when requiring remediation, any type of requirement would have to be reasonable?
No.
So it could be arbitrary, capricious.
No, it would have to be protective of public health, safety, and welfare.
But unreasonable. It could be unreasonable.
I don't think the word reasonable is used.
And it's not used, I'm telling you that. So I'm asking you as the expert, is reasonable part of the equation when the commission is asking operators to remediate or just in general operations? Is the commission under a duty to impose reasonable regulations or reasonable applications of its rules?
Yeah, I guess I don't understand the question.
Okay, you're out in the field, correct?
Yeah.
And you've come to a decision about designing a remediation program for this particular well, correct?
Yes.
And you've required other operators to do certain things to fall within what you believe the rules are, correct?
Yes.
And as part of your duties, do you believe that you're charged with the responsibility of ensuring that what you're requiring of operators is reasonable?
Yes.
Okay, that's, and I apologize if my question was too open-ended at the beginning, and that's all the questions I have.
Okay. You may if you can.
Okay, I have a question. Let's say that there is, I don't know, some event, and I need to shut this well in for some safety reason. I don't know, we've had a lot of wells recently we had to shut in because of floods.
Mm-hmm.
All right, I want to talk about that chute at 309 feet. I've got water flowing right now. If I understand it, if I potentially shut this well in for whatever reason, that I may break down at the chute, which means I could establish flow at that point and be pressuring up at 309 feet, which is going to make it awfully difficult for anybody in the area to manage that pressure because it's going to be outside of the normal limit. Am I misunderstanding something here?
No, that's correct. If that Braden head is shut in, we believe it would probably go back above 300 pounds per square
So
inch
I can
again.
break down, establish cross flow, and then be pressuring up at 309 feet.
Yes.
Okay, thank you.
And if I could follow up with that's, you could shut in the well and it would not affect the braiding head, that flow of water, correct?
Yes, you can shut in the well without shutting in the Braden head.
Okay.
But you cannot shut that Braden head in.
Britta, are you done with your case in chief?
Yes. Okay.
Do you
And,
want a time check?
I would love would.
Thought you might. You've got about 20 minutes left.
Okay, great.
Mr. Zinsky, you have about 43.
43, thank you. I would call Jim Graves to testify. Mr. Graves? Mr. Graves, can you identify yourself to the commission?
My name is Jim Graves. I'm operations manager for the Piance Basin for Merrilex Resources.
And how long have you had that position?
About 10 years,
And how long have you worked at Merrilex?
21 years.
And when did Merrilex begin overseeing the operation of the rightful 25-2 well?
I think we acquired that well in 1996.
And going back to how long have you been in the oil and gas industry?
Since 1972.
And currently you're the production supervisor?
operations manager, yes.
And could you briefly, in a couple sentences, describe what that entails?
I'm responsible for all the wells in the Piance Basin and our lease operators and any work that needs to be done on the wells, downhole work, supervised.
And when did you first realize that there may be a potential for water flowing between the surface casing and the production casing at the 25-2 well?
I believe that was in June of 2011.
And how did you become aware of that?
Well, we had an order to conduct a Bradenhead test, so I went out there when at that time the Bradenhead was below ground level, and so we exposed the Bradenhead and gained access to the surface casing valve and installed a pressure gauge on it, and saw at that time that it had pressure on it.
And what was the, did you report your findings?
Yes, the pressure, and then I opened the valve when we had water at the surface. So I reported all my numbers and observations to our Ignacio office.
And then what was the next thing that you did in connection with the Rifle 25-2 well?
Well, there were some directives from the environmental group as to testing that water and testing all the water wells within a half a mile of that location, observations of the surface water to see if we noted any gas or anything in the surface waters. And then in September of that year, I ran a pipeline from the Bradenhead to the water production tank, and so we could allow that water to flow and bring down that pressure on it to 50 pounds or so.
And you did that in conjunction with a directive by the commission?
Yes.
And since you received that directive, I think it's marked as Exhibit D, has Marilex been following that directive?
Yes, sir.
And have you ever observed any surface water around the area, detected any gas?
No, sir.
You said you tested all the wells within a half
Half a mile.
and these are water wells you're talking about?
Yes, sir.
And has anyone ever notified you of any problems with the water wells?
Not to me.
Now let's talk about the separator. There's some testimony about or some stipulation that the separator was not on site. Can you explain why the separator was removed?
I had taken the original lease separator, the one that was there, and had sent it in to be hydro tested and repaired. And then I got a test separator. I rented one and installed it on the well in order we were going to produce the well for sales. And then we were notified by the BLM that they wanted a 72-hour flow test on two other wells that we had in the area, one of them being the Federal 26-3. So I had the two lease separators on the other two wells were in for repairs also. So I took that test separator off of the Rifle Walton and then put it on each of the next two wells to get the 72-hour flow test required. I had no intention of temporarily or abandoning the well or any other thing. I just needed that test separator to satisfy the requirements from the BLM for flow tests on two additional wells.
And you got a letter from the BLM, that's Exhibit E?
Yes, sir, about the Federal 26-3. Yes, sir.
And now, when did you return the separator? Why did it take so long to return the separator to the 25-2 well?
Well, they got through with the repairs on the original lease separator. The test separator was up on the Federal 26-3, and that was December, and we had weather issues. And then we also had water disposal issues. We were starting to reclaim our evaporation pond we had in the area. And I believe at that time I was then made aware that we were going to have to conduct MIT on the Rifle Walton well because the state had said that we had temporarily abandoned the well, and I couldn't return it to production anyway.
So at that point, there wasn't a need to return the separator.
Yeah, exactly. But when I got the one that had been repaired ready, I put it back on the well in February.
And could the well, the Rifle Walton 25-2 well, produce gas without the separator?
It could produce gas, yeah. You couldn't sell it, but you could produce the well.
And did you conduct, were you in charge of conducting the MIT on the Rifle Walton 25-2 well?
Yes, sir.
And that's Exhibit J, that's the report that was filed with the commission?
Is that the one done in January?
Yes.
Yes, sir.
Okay, you have that in front of you.
Yes, sir.
What did you find when you conducted the MIT?
That we had a leak in the casing, and then we isolated that leak.
And did you fix it at that time?
No, sir.
And why not?
Well, we had submitted a procedure, and then there was some correspondence about what needed to be done. And so at that time, I had other work I needed to do with that rig. So we moved the rig off that location until it was decided what needed to be done, and went and did some other MITs.
And then you came back and eventually did a
Yes.
successful MIT on this one?
Yes, sir.
And I want to talk real quickly about bridge plugs. There was some, you put a bridge plug at 7,680 feet.
Yes, sir.
Why did you do that?
To isolate and protect the producing interval in the well.
And that's a standard procedure with conducting an MIT.
Yes, sir.
And did you remove the bridge plug after completing the MIT?
We did.
And is that standard procedure?
Yes, sir. That particular plug is a rental item, and you need to get it out of there and return it. So we did. And then you can have your well ready for production if it was a successful test.
And then let's talk about the second MIT. There was a 13-step procedure that the staff required Merrilex to perform before I guess the 14th step was the MIT. It's in Exhibit 9. Did you follow those steps?
Yes, sir.
Did you eventually conduct a successful MIT on the Rifle Walton?
We did.
And that was on, what was the date? April
1st.
And did you, well, I guess before the MIT, did you fix the leak?
Yes.
Now, is there any connection, and you're based upon your experience, you had a leak and you found the leak at 5,675 feet, correct?
Yes, between that interval and 5790, within a 15-foot interval.
And now that small leak in the production casing, to your knowledge, could that have caused have any communication with the water that was flowing between the production casing and the surface casing?
Not to my mind, because that well will build up in excess of sometimes 2,000 pounds on that 4.5 production casing. And to my mind, if you had a leak in that production casing that was migrating up the hole, you'd see, gas flowing or quite a bit of pressure on the surface casing, which we didn't observe.
And after you fixed that leak, there was no change in the flow of water between the production casing and the surface casing?
No, sir.
And that's all the questions I have for for this witness.
Yes, just a few. Good afternoon, Mr. Graves.
Good afternoon.
You testified on direct that the separator was removed from the Rifle Walton 25-2 well and taken to the federal 26-3 well. Is that correct?
If there was one intervening well that I tested with that before I moved it to the federal 26-3.
And when was the separator removed from the Rifle Walton 25-2 well?
The test separator must have, I think, in October. I took it off.
Okay. And this was the purpose for both the test separator and originally the separator on the Rifle 25-2 well. Both of those separators were being used for a 72-hour flow test.
No, just that one test separator. The original lease separator had been sent into the shop for hydro testing. I didn't get it back and set it till February.
But the original separator was being used for the 72-hour flow test.
No.
Or
The test separator was.
the test separator
The one I
was.
rented, yeah.
Okay. So the test separator could have been returned to the Rifle Walton site within 72 hours.
After finishing the flow test. It is possible. I don't remember what the weather was doing, in December. And that particular well is up a mountain with a really bad road if it's inclement weather. I honestly don't remember what the weather was like. But again, at that time, I was aware that we were going to have to conduct an MIT on the Rifle Walton before we could return it to sales. So actually, there wasn't any hurry in my mind of getting the separator back there because I couldn't produce the gas anyway to sales until we did a test.
Okay. And you also testified that the separator was returned to the Rifle Walton 25-2 well in February of
Yes, it's
2015?
original lease separator.
Okay. So you agree that there was no separator on the site from October till February 26th?
Yes.
Okay. All right. Thank you. That's all I have.
No follow.
And sorry, did you just testify that this well is located up a bad road?
Well, in inclement weather, it was.
So if the Braden head, some reason, pressurizes and you can't get up the bad road to relieve the pressure, potentially you're going to break down the shoe. Is that correct?
Which well are you talking about?
This one, the
No,
rifle.
this one's not.
Okay, well, I misunderstood. I thought you were saying.
No,
Okay,
this federal 26-3 is
okay,
a mountain.
thank you. That's all.
Okay. Additional
No,
witnesses or?
no, Mr. Chairman. Oh, no questions. I have one more witness. No more questions for Mr. Graves.
Call your next witness.
Mr. O'Hare? And Ms. Murphy, how much time do I have?
18.
Let's turn it on and see what happens. Mr. O'Hare, could you introduce yourself to the commission?
Yes, my name is Mickey O'Hare, and I'm the president of Merrill-X Resources.
And could you give a brief background about your education related to oil and gas?
I have a Bachelor of Science degree in petroleum engineering from the New Mexico Institute of Mining and Technology. I worked for Amoco Production Company for 6 years immediately out of college, and then worked for a large independent here in Denver for another 3 years before starting Merrill-X Resources with my wife.
And when did you start Merrill-X?
In December of 1989.
And what kind of experience do you have as far as production, as far as braiding head testing? And well, let's go with braiding head testing.
I've been doing braiding head testing since probably the very beginning of the start of the company.
And what's your experience as far as just general production of wells and operation of wells?
I have a pretty broad background in petroleum engineering, including drilling, completion, workovers, operations, production, and reservoir engineering, going back to my Amoco days.
Thank you. And the parties have stipulated that Mr. O'Hare is an expert in petroleum engineering. Let's talk about the braiding head testing. Can you explain what happened at the Katie Eileen wells as far as braiding head testing goes?
Yes, I personally conducted the braiding head testing on the wells as early as 2007 when we took over operations from Sampson on those wells. And I recall digging out the braiding head valves. As Mr. Graves spoke earlier, those are usually below surface after the drilling is completed. And I recall on at least 2 occasions digging out those valves on the Katie Eileen wells and performing those tests.
The, and did you ever do any type of random sampling?
Yeah, on occasion I would go out and, as I was checking the wells, just open the Braden head valves to see if there was ever any pressure on them. And I never encountered pressures on any of the Katie Eileen wells.
And the, now, how, can you explain why the reports never got filed with the commission?
I honestly can't explain why. I believe anyway, that I had turned in the paperwork to one of our technicians who was responsible for filing that paperwork. We have no evidence of even my field notes in any of our well files. We found a number of blank Form 17s that had been signed by another engineer in our office, dated 2011. But that's the only evidence we have that anybody had been working on those forms. So I honestly don't know why they were not submitted. As president of the company, I take full responsibility for the failure of those forms to get to the COGCC.
And now, were tests performed on the wells in 2014?
Yes, all of the Katie Eileen wells were Braden head tested in November of 2014, and all of them passed that test with no indication of any kind of pressure on any of the Braden heads.
In that period that you'd been testing from 2007 to 2014, did you conduct any repairs on the Braden heads?
No, sir.
And so what does that establish as far as you're concerned as an engineer?
Well, it establishes that there never has been any kind of Braden head issues with any of the Katie Eileen wells. If there had been, we would have had to have repaired the Braden heads in order for them to pass the tests in 2014. And there's never been any kind of repair work or any work on the Braden heads on any of the Katie Eileen wells.
And let's talk about the federal 26.3, I believe it is. You were late in reporting a cement remediation. Do you recall that?
Yes, sir.
And can you explain what happened there?
Again, it was miscommunication between our field people and our office people. As soon as our production tech realized that there was work being done on the well, she contacted the COGCC, and I believe it was less than a half a day after the work was actually done that she submitted the proper paperwork to the state.
And so the federal 26.3 is up in the Piance, correct?
Yes, sir.
In your home office is in Ignacio.
Correct.
And so there's communication between the field up in Piance and the home office, correct?
Yes. And not always the best communication.
And this, and again, that's, you're taking responsibility for that.
Yes, sir.
Now, there's so let's talk about the water flow at the 25-2, the Rifle Walton well. When did you first become aware of that water flow?
After Jim performed the Braden head test on that well in 2011.
And did you propose a plan to the COGC to address that?
Yes, we did.
And that's, I'm putting before you Exhibit D. You've seen this before?
Yes, sir.
And on the second page, it has, at the very bottom, it says describe proposed or completed operations. Do you see that?
Yes, sir.
And is that what you proposed to the commission?
Yes, it is.
And did the commission accept that? Did they grant that?
Yes, sir.
And have you, since they required that, has Marilex followed the requirements set forth in this Exhibit D?
And to my knowledge, yes.
And now the water that's flowing between the surface casing and production casing, has that ever posed a threat to the environment, in your opinion?
No, sir. We had some testing done on that water very early on, even before the state sample is noted in, I believe it was July of 2011. And that test showed TDS of about 1,205 parts per million. So it's very fresh water, even fresher than some municipal drinking water.
Is there any evidence that that water is migrating up the annular of the production casing from a producing formation?
Not from a producing formation. If it was, the TDS content would be much higher. We have some water analysis on our produced water from 2 different zones in the 25-2 well, and the lowest TDS of that water is over 10,000 parts per million.
And has the water ever spilled out of the valve from that's collecting this water? How can you explain what the water's coming up and you're capturing it?
Yes, the water is piped directly into a tank, into a water holding tank, and that water is hauled off through water trucks to commercial disposal facilities at this time. I'm sure there, especially when we did the original Bradenhead test, that water came out on the ground. But again, it's fresh water and it has been contained since that time, or since September of 2011.
Now, are you familiar with the removal of the separator from the Rifle Walton 25-2?
Yes, I am.
Now, when the separator was removed, was the well capable of producing gas?
Yes, the well is, and always has been capable of producing gas, and it was never our intention to even temporarily abandon the well.
And could you use the gas for anything that if you wanted to produce it?
Yeah, and I'd like to point out that there is a very big difference between being capable of production and selling gas. Under the Commission's own definitions, if a well is capable of production, doesn't necessarily mean that it is selling gas. We can produce the well, even to the sales line, without a separator for a limited amount of time, if we hold enough back pressure on it to keep the water from coming to the surface. So a separator is not entirely necessary for selling gas. It's certainly not necessary for producing gas. At any time, we could put a generator, for instance, on the well and use the gas coming from the well to run the generator and generate electricity. The well is still capable of producing gas, even without the separator and having that gas utilized on site. Just as the Commission's forms show, production is different from sales. And that, to me, is a very important distinction that is not being taken into account by staff in forcing us into the position that we temporarily abandon our well by removing that separator.
I'll show you what's been marked as Exhibit 12, and it's production records from the COGCC. Do they get this data from forms that you submit to the COGCC?
Yes, they do.
And it has different columns. It has produced, flared, used, shrinkage, sold, in the BTU. Do you see that?
Yes, sir.
And now it says prod, P-R-O-D. I assume that means produced.
Production, yes, or produced.
Yeah, and then used. What does used mean?
That's what we use on location, either to run our separator or some other equipment.
And then there's a column, there's flared. There's a column if you have to flare gas, correct?
Right.
And there's a shrinkage column.
Correct.
And then the next column is sold.
Yes.
And by sold, that means into the pipeline for sale.
Yes, sir.
And now let's talk about the remediation plan. Mr. Berger testified. Do you have any particular issues with his remediation plan? First of all, did you try to negotiate something with him to address the water flow?
Yes, sir. I attempted to call Mr. Berger on a number of occasions, and we traded phone calls for, I think it was close to 2 weeks. Never did talk over the phone, so I sent him an email requesting his assistance and coming up with some kind of a procedure that would be acceptable to the state. And in my mind, there were two different issues there. The first issue was the repair of the small leak that we discovered at 5,675 to 5,690 feet. And the second separate independent issue was the water flow at the surface that we had been addressing since 2011.
And that's we have an exhibit F. Is that the emails that you were referring to?
Yes, sir.
And let's go back real quick on the MIT. There was a small leak at around 5,600 feet. Is there any connection between that small leak and the water that was flowing between the production casing and the surface casing?
No, sir.
And why do you say that?
Again, as Mr. Graves testified, we had seen casing pressures in excess of 2,000 pounds on this production casing. Had there been communication between that produced zone and the surface casing or Braden head valve, we would have blown out that valve. That valve was only rated to 500 pounds. So had there been direct communication with that kind of pressure, we would have known it. We never saw any kind of pressures, especially after we started venting the well in excess of 50 to 55 PSI. In addition, we haven't seen any measurable gas at that casing head, at the Braden head. If there was communication between that producing zone and the Braden head, we definitely would have seen gas, especially with those kind of pressures.
Now, Mr. Berger testified that there was no, the top of cement was around 5,000 feet. Do you 5,120 feet, according to the CBL? You have Exhibit 10 in front of you. Is that the CBL?
Yes, it is.
Cement bond log?
Yes.
Does that indicate any cement above 5,120 feet?
Yes, it does, in fact. Mr. Berger called the top of cement at 5,120, but that is very misleading from the standpoint that there's quite a bit of cement above that depth. It may not be the same magnitude of bond that is exhibited below 5,120 feet, but there's definitely evidence on the CBL of cement as high as 1,800 feet, and in one place even higher than that.
Now, is there any correlation you could see between the CBL and the different squeezes that he's recommending? And those squeezes, I think the first one between 810 to 910 feet.
Yeah, the CBL actually shows some kind of cement at those depths. It's not very good bond, but there is apparently some cement in the annulus of the pipe at that depth. I don't see anything in that interval that, at least from the CBL, that would indicate that there's a fresh water zone there. There's some very thin laminated sands that could possibly be contributing water, but we don't have enough information on the CBL to verify that.
And would you agree with Mr. Berger's testimony that it's hard to determine where the water is coming from?
I would agree to a certain extent that we don't know where the water is coming from. We do know it's not coming from an oil and gas producing zone. Again, we've tested that water extensively, and there is no evidence of hydrocarbons in that water, at least in any significant measurable degree.
do you agree that it's possible that the remediation plan proposed by staff would weaken the integrity of the production casing?
It definitely would weaken the integrity of the production casing. Anytime you punch holes in casing, you're weakening it. And the integrity of that pipe is compromised even after you pump cement through it. As the witness, I believe, testified or agreed to anyway, steel is much stronger than cement. And water running against steel versus water running against cement, there's a much greater chance of erosion of that cement than there is of the steel, especially fresh water.
And is there, I believe, and I want to characterize this testimony, but I'll just ask you a straight question. Is there any certainty that the staff's remediation plan will stop the flow of water between the production casing and the surface casing?
No, there is no certainty there, especially when you're pumping cement that may be getting mixed with fresh water. You're weakening that cement as you're pumping it into the ground, and it's being mixed with that fresh water from underground. So even multiple attempts at squeezing off those holes may not shut off that water. But even if it did, if the pressure that we're seeing at the Braden head is indicative of that pressure out away from the wellbore, if we shut it off at the wellbore, there's nothing to keep it from breaking down the formations out away from the wellbore and coming to the surface at some point that we have no control over.
And is the current remediation system in place? Do you believe whether that's a better option than the staff remediation?
We think it's a much better option for at least 4 reasons. Number one, we know that we can contain the water. We know it's fresh water that is not having a negative impact on the environment, and we are able to keep that fresh water contained in an existing tank and hauled off to an appropriate disposal facility. Number two, there is no possibility of us degrading the integrity of our production casing through our existing method of handling that water. Mr. Berger's suggested repairs has a great deal of risk at degrading the integrity of our production casing. Number three, Mr. Berger's suggested repairs has a great deal of risk in causing that water that is flowing under pressure from below the ground, coming up somewhere outside of the existing casing and allowing us to control that water. We don't know where it will come up. Mr. Berger failed to mention that there is an active stream that flows year-round that has a very high head on it. It comes from much higher in the mountains than our well is located, and that could be the source of that water that we see coming out of our well.
And is that the East Divide Creek?
Yes, sir.
And that's on Exhibit 2, on the first page of Exhibit 2?
Correct.
It says creek flows to the northwest. Do you see that?
Yes, sir.
That's what you're talking about?
That's correct.
Okay, continue.
And number four, the economics of performing Mr. Berger's required remediation will make the well uneconomic and force us into plugging and abandoning that well. And even if we have to do the same cement pumping on that well bore as we would to continue to produce it, there's no guarantee that we will be able to contain the flow of that water. We know we won't be able to contain it at the wellbore once it's plugged and abandoned. And so it's anybody's guess as to where that water will pop up on the surface.
And going through the economics, you have an Exhibit G, which shows how much money Marilex has spent to date on this.
Yes, sir.
And this is from your records related to the
This is
costs incurred.
This is from the work that was done in January and in April, or late March, early April. The first was the attempt to, I'm gonna find an exhibit.
Oh, here, just look at mine.
This shows the total amount of costs that we incurred to attempt the first MIT that failed in January, and then the repair work that we did in March, and the final MIT on April 1st. So to date, as of that date, we had spent somewhere around $97,000 for that work.
And Exhibit H, can you explain what that is?
Exhibit H is an AFE that I prepared to do the work that the state is requesting. This takes into account some contingencies, and I think it shows there about $12,000 worth of the total is in contingency costs. So our total estimate to do that remediation that the state is requesting is over $135,000.
And Ms. Beckstead asked Mr. Graves, I think that or asked somebody, it might have cost more money if you had kept the rig on site. How much money would you, and done the remediation at that point, how much money would you have saved?
We would have saved about $4,000.
Okay, and that's the mobilization cost?
Correct.
And then finally, Exhibit I, can you explain what that is?
These are the economics that we ran to determine the current and then the future value of the well under the costs that we've already incurred, and then the costs that the state was requiring us to incur.
And then what's the result of that? Or what's the bottom line?
Well, first,
when I say that, I actually mean it this time.
yeah. The bottom line is that it's uneconomic to produce a well, even after the expenses that we've incurred to date. Adding to that, the $135,000 that the state is requesting makes the value of the well extremely negative in the amount of, gives us a PB10 of negative $215,000.
And that's all the questions I have.
Any cross?
Yes, for a quick time check. Okay, thanks. Good afternoon, Mr. O'Hare.
Hi.
First, just a few quick questions about the Bradenhead test. You testified on direct that there are no notes, no emails, no other documentation regarding any of these tests, correct?
Not that we could find in our files.
Even those that allegedly occurred in 2013?
We can't find any notes, even field notes, on those tests. That's correct.
And turning now to the remediation issue at the Rifle Walton 25-2 well. Do you agree that when the Bradenhead valve is opened at the well, water flows continuously as of today?
Yes, ma'am.
And has Merrilex ever proposed a cement remediation procedure designed to stop this flow?
No, we have not, because of the reasons I gave previously. That would be much too risky in our view.
And you also testified on direct that we don't have enough information to formulate this remediation plan. Is that correct?
No, ma'am.
However, Merrilex has not performed a noise or temperature log, which would allow us to have more information, correct?
At the low flow rates that we see from the Braden Head, those logs are not likely to work.
Okay, turning now to the source of the water. You testified that the source of the water could be coming from the surface from East Divide Creek, is that correct?
Yeah, I'm testifying that it could be recharged by the flow from East Divide Creek. Yes, ma'am.
Okay. And all groundwater is typically recharged from surface water, isn't that right?
Yes, ma'am. I should qualify that by saying most, not all.
And you also testified that Marilux's preferred remediation or resolution of this issue was to let the water flow out of the Braden Head annulus for the foreseeable future.
So long as we are capturing that water, yes.
And so this would occur until the water supply runs dry.
I would expect our well to run dry before the water supply runs dry.
Okay. And turning to the economics of this remediation, you testified on direct that performing the remediation as required by staff would render the well uneconomic, correct?
Yes, ma'am.
And this was your belief in 2011 when staff first required the repairs.
Yes, ma'am.
But since staff approved the Form 4 on September 12, 2011, which allowed the flowing of the water to the tank, isn't it true that Marilux has only produced the well for 78 days?
I don't have that information.
Okay. And has only sold about 1,300 MMCF over those 4 years?
Again, I don't have that information in front of me.
Okay, thank you.
Okay. We have a case in chief and a case in chief.
I have one just follow-up.
Okay.
Mr. O'Hare, the reason you're not producing from this, is it because of from this particular well, is it the gas prices right now?
Yes, gas prices have been very low starting in 2011. We had one little bump in 2013, and they're back down to about $2 an MCF at this point.
So for this particular well, you made a business decision not to produce until gas prices increase?
That's correct.
And that's all the questions I have.
All right. We have some closing statements, or do we?
Can we ask the witness some questions?
Well, certainly.
So this well doesn't appear to be it's not economic right now to produce.
At current prices, no.
Okay. And my concern is when we get ready to abandon the well, how are we going to shut off the water?
Again, I have some issues with that because I believe that it will be detrimental to try to squeeze it as the state has required. The landowner has the right to that water if he has water rights on his place. And so my hope would be that it would be used as a water well for the landowner, even upon abandonment of the well.
Well, the landowner could use the well for a water well, but there's still no way to close the well in, to shut that flow.
Not and maintain control of that flow. Again, I believe if you shut it in, there will be some ramifications somewhere unknown to us. We don't know where that spring may pop up.
But it wasn't flowing until we opened the Braden Head. So it was there was some kind of integrity prior to that point.
We don't know if there is a spring someplace else that is being relieved by this.
Right.
It wasn't on location, but
Not on location.
there could have been one someplace closer to the creek, or we don't know.
Yeah. Well, it is a dilemma, isn't it?
Mm-hmm.
Thank you.
Can I ask some questions too?
Yes, ma'am.
I just have a few questions. Prior to the squeeze on March 26, 2015 with the 30 sacks of cement, where was the top of cement at that point?
We don't have a CBL that would show that. Again, we believe that the top of cement has not changed. We see the top of cement much higher than the the 5,120 feet that the state is noting. And in our view, it is well above 1,800 feet. And we don't think that changed after our squeeze on March 26, because we didn't even get 30 sacks through the hole. We were only able to squeeze about 1.5 barrels into the hole before it locked up on us. So we drilled out over 200 feet of cement in the casing and had no impact on the top of cement with our squeeze at that point.
Is it possible that the holes in the casing that were discovered at 5675, is it possible that those were corrosion?
Yes, that's possible.
Could the corrosion have been the result of oxygen in the water that was on the backside coming from this source of water in the well?
No, ma'am, we don't believe so.
You don't believe so, but you don't know.
We can surmise that that water was not getting to that depth from the freshness of that water and the fact that there is cement at least 600 feet above, good solid bonded cement, at least 600 feet above that depth.
With the water that is now on the backside, is it possible that there is oxygen in that water that could cause corrosion at shallower depths?
It's possible, yes.
If we get into that situation, I've got a well that is producing from, what does it say here, 7,500 feet?
Yes, ma'am.
That's a heck of a lot of pressure that's all of a sudden going to be going through a hole in the production stream to a shoe at 309 feet, right?
Yes, if there is a loss of mechanical integrity on that well, that's a good possibility. And that's another reason that we think it is imperative that we do not put holes in that casing at shallow depths.
But is it possible that I could get holes because of corrosion in the production stream just because I have water on the backside and flow?
It is possible. Fresh water is much less corrosive than brackish water is.
Agreed.
And so we think it's less risky than punching holes in that casing. There's less chance of that corrosion happening in the short term than there is of having some severe problems with punching holes into that casing intentionally and then trying to squeeze them off.
How are you going to know? I mean, are you just going to go ahead and do a mechanical integrity test will probably be too late because you'll get a hole at some point and that pressure is going to go on the backside. I mean, I'm concerned about well control here.
We're monitoring the backside pretty much on a daily basis by the flow of that fluid into our tank. So if for some reason we see a lot more flow than what we have been seeing for years, that would be an indication that there is something else going on down
Not
the
just
hole.
flow, it's going to be pressure, right?
Right.
Okay.
Mr. Custer, there was a time when your agency gave a permit to release water into a stream. Is this anywhere near a possibility for this situation?
I'm not sure of the question, but yes, I'm not sure of the question, but the Water Quality Control Division does issue discharge permits for surface discharges. Those are dependent on the stream characteristics and the parameters in that stream as to what those discharge limits would be.
But we don't have available the TDS for Divide Creek.
Not that I'm aware of. I do know that the EPA has set a secondary standard for TDS at 500 parts per million. That's based more on aesthetics. It's not really health related. However, it could, at 500 milligrams per, or at 500 parts per million, it could create problems in your stomach, and certainly the water would be not clear. It would appear to be a little bit cloudy.
Okay, thank you, sir. Okay, any other questions for these folks? And maybe we could have closing statements, assuming there are some.
I'll wait. Time check.
15 minutes.
Whew.
Mr. Zinsky, you have 7 minutes.
I'll use, excuse me. The majority of my time here to discuss the issues at the Rifle Walton 25-2 well, which, as you can tell, is the most contentious issue here. However, first I'd like to make a few quick points regarding the other violations. First of all, 12 Braden head tests weren't performed, and Miralex cannot produce any written documentation regarding these tests at all. No field notes, no emails or other documentation. If the tests were performed, it seems like it would have been worth their while to at least keep some notation. Furthermore, the failure to submit the documentation, which is undisputed, is a violation of Commission rules. And turning to the violations at the Federal 26-3 well, Miralex argued briefly that the Rule 317E violation should not be penalized because it was an administrative error or a miscommunication. And as an oil and gas operator, Miralex has the responsibility to ensure that these sort of errors don't happen. That did not happen here. And regarding the 605B7 violation, Miralex has provided no evidence or argument to refute staff's assertion that this violation occurred or that the $10,000 penalty should be reduced. Turning now to the Rifle Walton 25-2 well, and the issue of the separator removal and the temporarily abandoned status. Miralex seems to want to ignore this commission's definition of what a temporarily abandoned well is. It explicitly states that a well is incapable of production when a separator is not on the site. As Mr. Graves testified, there was no separator on the site, at least from November 7th, 2014 to February 26th, 2015. And the reason why the separator was removed in the first place, or what exchange of separators happened, is irrelevant. You know, the intention for removing the separator doesn't matter for the purposes of the fact that the well was temporarily abandoned after it was removed. Second of all, there's some confusion about how a 72-hour flow test, which is a 3-day test, could take 4 months. And turning to the issue of whether the commission has the authority to require the remediation and whether we should require the remediation. 7 to 13 barrels of water are flowing out of the Braden Head annulus per day. What we know for certain is that there's water in the wellbore, and that means it came from somewhere else. We also know that there's a creek nearby, as well as several water wells. Staff has testified that they believe that this water is coming from a groundwater formation, and a lot of the evidence points to that. Staff has also admitted that we don't know precisely what formation it is, but that is largely because staff has not received the required information from Miralex regarding some more specific types of logs, like a noise or temperature log, and in fact did not receive a cement bond log until very recently. Also, regarding the commission's authority to require this, there is a continuous flow of liquid coming out of the Braden Head annulus, and that seems to be undisputed. it also appears undisputed that Merrilex never proposed a cement remediation procedure. I understand that Merrilex might have some issues with staff's proposed procedure, but it is in fact, it is the operator's burden to come up with a cement procedure that works at a particular well. And staff is struggling here to try and come up with something that will work, and has done so and devoted extensive time and resources to do so. Instead of proposing a remediation procedure, Merrilex has instead said, oh, we'll just let the water flow for the foreseeable future. And maybe it could go into a stream. But the problem is that we don't know where that water is coming from and what it is doing far underground. It could be depleting an aquifer. It could be depleting water well sources. We just don't know. And is that a risk we want to take for the foreseeable future? Merrilex has also presented testimony asserting that there hasn't been an environmental impact because water sampling data from 4 years ago showed that the water had no contaminants in it. First of all, this data was taken 4 years ago. This water has been flowing for 4 years, and this might have changed drastically. We don't know. In addition, as I stated before, the risks are here what could be happening far underground to the water-bearing formations themselves, not necessarily the water that is expressing from the Braden Head annulus today. And there also has been some contention regarding whether the deep casing leak could have caused some issues today in 2015 with that water. Again, we don't know for certain, but as Commissioner Craig pointed out, this could have been the result of corrosion that was the cause of the water flowing behind the production casing. So this comes down to the fact that we don't know what the state of the water is in 2015, and we don't know what it will be in 2020 at this point. However, we do know that it was relatively clean in 2011 and that there has been downhole casing integrity issues since that time. Do we wait and see what happens, as Merrilex would like us to do, maintain the status quo, or do we take action and try something else? Because currently the current remediation of the flowing to the tank is not working. Lastly, turning to the issue of whether this required remediation is arbitrary and capricious. First of all, this procedure was developed after exercising another option, allowing the flowing to the tank for 4 years, which has not worked. And as Mr. Berger testified, it is a decision based on a cement bond log and his analysis of the data that's available. The required cement squeezes that staff has developed are carefully chosen to isolate the zones that could be potential sources of the water. Merrilex has made some argument that punching holes in the casing in order to put more cement there could end up weakening the casing more in the long term. But again, is it the wait and see, or do we try and do something now? There is always a small possibility that something could happen as a contingency when you're working downhole. We can't anticipate every little thing. But if the balance of costs and benefits are looked at here, it's much more beneficial to take action and provide the extra cement than to see if multiple holes appear, perhaps a flood happens and we have to shut in the Braden Head but can't, pressure builds. I mean, the list could go on about the potential scenarios that could happen here. Mr. O'Hare also testified that performing the repairs necessary to stop the flow would render the well uneconomic. But the well is already uneconomic. And this was Merrilex's excuse back in 2011. And as you can see from Exhibit 12, this well has only produced 1,300 MMCF since that time. In addition, staff would require this repair regardless if Merrilex was to produce the well or plug and abandon the well. It is a necessary cost to prevent harm to the public welfare and the environment. And as Mr. Berger testified, there have been other operators with similar situations at wells, and they have voluntarily performed this remediation because they have recognized that it is necessary. As a result of all these facts, staff requests that the commission makes the following findings regarding the Rule 319B1 violation. The Rifle Walton 25-2 well was temporarily abandoned from November 7th, 2014 to February 26, 2015 because there was no separator on the location and therefore the well was incapable of production under commission rules. Second, the commission has the authority to require the remediation. And lastly, staff's required remediation is not arbitrary and capricious because the data and analysis demonstrate the need to stop the water flow and the likelihood that the remediation will be successful in doing so. Staff respectfully requests that this commission find Merrilex in violation of Order 11285, Rules 317E, 319B1, and 605B7. Impose a penalty of $100,100 and require Merrilex to perform the annular flow remediation at the Rifle Walton 25-2 well within 30 days of the entry of the order. This commission should not tolerate refusals to remediate where water is flowing out of a wellhead. Merrilex was given plenty of opportunities to work with staff in order to develop some alternative. In fact, Merrilex's defenses don't hold water before a commission charged with protection of public welfare and the environment. Thank you for your time today.
Is that a pun?
Yes.
Developing a reputation.
Mr. Zemsky, you have a.
Yes, I do. And how much time do I have again?
Just over 7 minutes.
Okay. Briefly, thank you for taking the time to hear this this case. As far as the braiding head testing, we're admitting, we, Merrilex, screwed up. We're not asking not to be penalized, but we think $40,000 would be excessive, and we're suggesting a penalty of $2,500 per well, $10,000. It's a significant amount of money, and that's what we're asking as far as that goes. The bird protector is a $10,000 fine. We're not arguing that that was something that was not done, and we're not arguing a reduction there. But we are requesting that the $2,500 fine for the reporting of the cement remediation, which was half a day late, be waived in this instance. Now, as far as the I believe $47,600 for the temporary abandonment, we think it's a legal issue. We think the definition is clear. It says to be temporarily abandoned, quote, a well, quote, a well which is defined as, quote, a well which is incapable of production or injection without the addition of several pieces. There's testimony that the well could have produced. It could not have been sold. It actually, there was testimony it could be produced and sold for a very short amount of time before the water got, but it could be used, and it's traditionally, there's always some gas being used on site, so it was capable of production. And the separators, it wasn't gone for 4 months just because it was gone for 4 months. There was some, it was taken in October, and then November 7th, I think it was October 24th, November 7th, there was an MIT that had to be repaired. We was the notice of apparent violation. So there was no need at that point to return the separator to the well site because they weren't going to be able to produce anyway. And we did file a request for temporary abandonment, but that we didn't think we had to. We did that because the commission said you need to, so we did. So it wasn't like an admission. It wasn't an admission at any point that it was temporarily abandoned. Now, as far as the remedial recommendations, we're not refusing to remediate. We just want something that's reasonable. We don't believe, based upon Mr. Berger's testimony analysis of the data, that what they're proposing is reasonable. The commission has, or the staff has the power to require remediation, but they're not required to impose remediation. If they believe it needs remediated, they can propose something, but it has to be reasonable. And I believe with all the uncertainty involved in this case and the source of the water, whether this will actually remediate the well, whether it's actually going to cause more problems than what's currently there, I think there's enough of uncertainty that this particular proposal should be rejected by the commission. We believe that the current process, the current procedure that is in place has been addressing the problem. And there's suggested there's a third way that you reject both of our proposals and say, come back to us with something else that is reasonable. You could say, well, what Marilex is doing now, maybe that's not reasonable, but the staff's recommendations at this point, that's not reasonable. Either give us 60 days to come up with something, give us, something else where we could try to reach an agreement as far as it goes. And that's one option. We actually think the status quo is fine. I think Chairman Compton suggested possibly maybe we can, this water could be discharged. I know I had a client in Archuleta County that was going to do that and was working with the Division of Water Resources, and they pulled the idea based upon some Southern Ute tribal opposition. So they, wanted to work with the tribe, so they withdrew that, and the tribe just had some other issues. But that is a possibility. If we could, if the concern is we're draining water from an aquifer, this is fresh water, and we could put it back in. If it's coming from an aquifer, there is no evidence that it's coming from a producing formation. And we're not refusing. We just want something that's reasonable. Now, Mr. Berger testified a bit about other wells and other remediation and operators agreeing to those remediations, but we're not really sure. I mean, maybe those remediations made sense. Maybe there was a clear indication, okay, hey, this is going to solve the problem. Let's put our heads together. Hey, we agree that this is going to solve it. We'll do that. Here we're at loggerheads, so to speak, that we don't agree that how to handle this. So we're asking that, if you're not satisfied with the status quo, doesn't mean you should, stamp the staff's remediation. You could reject both of ours and give the parties time to come back with a third way. That's a possibility. So, but what the staff is recommending at this point, we believe is unreasonable because there's too many uncertainties, and it could actually cause more damage and more harm than what the status quo is. Thank you.
Okay, you have any questions for these folks before we close the record? I think we'll close the record then. Okay, remind me, Council, if do we as a commission have any leeway in terms of adjusting fines or recommending?
Yes, sir.
So none of these are those, I forgot, third tier fines that are.
No, many of which are controlled by the old act, and the class impact is identified in this column here, and there's only 2 of those, 5 and 7.
Okay, thank you.
Staff is seeking that treatment.
All right. Let's have a discussion, especially from you very intelligent engineers.
Mr. Chairman, if I might start on this. Before we address the issue of the fines, I think we need to have just a little deliberation on what we think we need to do with the well that's flowing water. I'm not comfortable just letting the well flow water. And I
Makes two of us.
am concerned, that, you're taking some risk by trying to perforate, squeeze, and shut that off. I don't really have a better solution right now, but what I would think about is to give Marilex 30 days to propose an alternate water shutoff solution, and failing that, then to go with the staff's recommendation. I don't know what an alternative might be. And it may require getting some additional water sampling to see, what is the current TDS of the water that's flowing? What is the TDS of some of the other producing horizons, whether they're fresh water or some other producing wells around, just to help identify what's actually coming out at the surface. And that might guide them a little bit on how they want to try to do the water shutoff. But I think there needs to be some kind of plan in place to take care of that.
I'm in agreement with that. There was a hydrologist here a moment ago, wasn't there? Well, we can't ask him anything, but I know that down in, if you excuse the language, my neck of the woods, they're able to put some kinds of flags in the irrigation ditches in this case, but in this case it would be in Divide Creek, and actually determine if any of that Divide Creek water is ending up down in that water that's coming out of the annulus. I don't know the time it takes for that. I know we had it down there for like a spring for the irrigation season, so it would take probably more than 30 days to make that determination. Simple, seems simple. Water sampling the creek and water sampling the water coming out might give you some indication of whether or not.
Well, and I think the big issue is, it's flowing water today, and the well's not economic, and at some point it's going to have to be addressed because they're going to want to plug the well. And whether that's 2015 or 2020 or 2000 whatever, at some point there's going to have to be a plan on how to shut the water off, and so we need to address that now. We can't just let that float, so to speak, forever.
I'm in agreement with you. I will support, if that happened to show up in a motion at some time, I will support it. Other discussion?
Yes. It's just
The issue of temporary abandonment.
Yeah.
What are your thoughts about that?
How are they going to do it? What's the corrective action? And the penalties we can address that with some more discussion.
Are you guys having a discussion?
We are.
You're leaving us
I
out?
was just kind of clarifying that we're looking at claim number 8. Really just what is the corrective action? How do you identify that? And we, maybe have 30 days to come back with some kind of a recommended plan of some sort on that. But as far as the penalties, I just said that's going to take further discussion.
Okay.
Just as a comment that ties on with what Commissioner Hawkins said, in my humble opinion, this well lacks wellbore integrity, which is something that this commission has tried to go ahead and get a grip on throughout the state, because that's our credibility, is that wells maintain wellbore integrity. Maybe I'm missing something here, but
It's past MIT's, hasn't it?
it's flowing on the backside and I can't shut that well in.
I forgot. There are 2 directions.
Yeah. I mean, there are times when you want to shut wells in, 100% nothing, and I can't do that right now. I just have a real, I just have a philosophical issue with that, because that implies to me we don't have control of the well. And maybe this is in an area that has a low probability of occurrence that will ever mandate that a well gets totally shut in. But we have to face the full risk of a possibility across the state. I'm going to ask a question of Stuart. Do we have any other wells in the state that don't have wellbore integrity and we're allowing to flow? Yes?
I don't know.
I'm just curious. I mean,
I'm not sure you want to open that.
all right, I won't
We've closed
open
the
that up.
record.
But
There may be other
there's
well
my
issues.
comment.
Let's focus on this one.
oh, on this one, I'm going to have to be convinced that I have wellbore integrity in this well. And right now, I don't feel like I've got it. So, and I have a real question about the commission starting to go ahead and say, okay, you don't have it, but it's okay. So I just have a problem.
Okay, any other issues? Temporary abandonment question. You're happy that it,
Talk that.
by definition, it was temporarily abandoned?
We'll come in here. Oh, okay.
The heater, the wildlife screen, that's fairly settled. All right, anything else? You want to talk about the fines, or? Alex has asked that Bradenhead testing, which they admit to failing to report, but have testified that they did, that those fines be reduced somewhat. How do you get them to talk?
Mr. Chairman?
Oh, yes.
Well, if you want someone to talk. The, on claims 1, 2, 3, and 4 in the Bradenhead testing, I would be all for a persuasive argument as to why fines should be reduced from staff recommendations. In this case, I don't see it. I see the facts supporting the recommendation.
Okay.
Thank you.
Anything else? If no further discussion.
I've got issues with
Mr.
7
Chairman.
and 8.
Okay, wait a minute, here we go.
There's a lot of problems there. I don't, we've got one that's going to let it flow, which I don't agree with. The other one is it might work, but might not. I mean, those are our two options. That's it, really. I mean, I don't know that this whole thing, number 7, that Rifle Walton 25-2 shouldn't come back in 60 days with plans to fix it. Right now, we're not doing anything.
Okay, we've got a couple, three of you seem to be headed in that direction. Commissioner Walk?
I was just going to add to Commissioner Spielman's observation that I think I feel pretty certain about 1 through 6, but it's really 7 and 8 that we seem to be more concerned about. What do things look like going forward, rather than just agreeing with the penalty and moving on. So that being said, I'd like to make a motion that we approve staff recommendations for penalty and violations on 1 through 6 and seek additional information. Is 30 days too short as I'm making the motion?
Probably should give them 60. That's when our next hearing is anyway.
60 days till the next hearing to make a determination on 7 and 8 to allow for that additional information to be provided by staff in working with the company.
We have a motion
Second.
and a second. Further discussion, Commissioner Allward.
Thank you, Mr. Chair. I would be willing to consider some fine suspension possibility upon successfully remediating this Rifle Walton well.
On 7, you mean?
And accomplishing 7, I think if they move forward aggressively and successfully, I think that we should perhaps include in the motion some suspension of some part of this fine, because if that...
It's fine. I mean, my intention was not even to consider anything on that until the next time we meet. So we can say temporarily suspend that fine until we receive the additional information, however you want to word it is fine.
I mean, I would like it to be out there so that the operator knows that, you know, this good faith effort that we're trying to work towards will have significant payoff, and that we assure that we get to where we all want to be. I don't think anyone in this room is really focused on the fine amounts, but rather the protection of public health, safety, and welfare and these water resources.
Sounds reasonable to have some incentive to encourage.
How would this come back? Would this come back as a hearing item again?
Well, I have a question too, actually.
I'm not sure. You allowed to ask?
For the record, can we get a second and then have?
We had a second from Commissioner Spielman.
Okay.
My question is, do you intend to take final agency action today? Because I'm hearing some discussion like you want to do that on claims 1 through 6, but I'm not so sure on claims 7 and 8. And if you don't want to take final agency action, explicitly say that you don't want to do it on claims 7 and 8.
That's my intent of the motion.
So we'll add that wording in the motion that we intend to take final agency action on items 1 through 6, but not on 7 and 8. And that's acceptable to the motion maker and seconder?
Yes, Mr. Chairman.
Okay.
My only question is, I guess, to Dave on the amount of time. I'd kind of like to see the staff and Marilex go over the options, or have Marilex present an alternative to staff and on the proposal, and let them have a chance to kind of think about it before the hearing date. So we might, I mean, maybe we give them 45 days and the staff has 2 weeks or some period of time to kind of interact and evaluate. I don't want them to bring it to the staff 60 days from now, and on the day of our hearing, staff hasn't really had a chance to look at it.
Okay. Makes sense.
Makes sense to us.
I don't know how you.
So I'd take 45 days to, or at least let's include some language to consult with staff on the proposal prior to our hearing, the next hearing.
No later than 45 days from today. Or, okay. All right. I guess that's another friendly amendment.
I mean, it complicates things. It's not going to serve Marilex well if they wait 60 days to do that. So I don't know if we have to be that prescriptive. It's going to be reevaluated at the next meeting in 2 months. If we find out that no work got done or that nothing was submitted until the day before, I think that that speaks to.
That
the
that would
amount of
cloud our
consideration
judgment
we should
pretty
give. So
severely.
Okay,
I agree with the
understand.
intent, but I'm just
Agreed.
trying to keep it simple.
Okay. I have no problem with that.
All right. We have a motion to accept the staff's recommendation on item 1 through 6, take final agency action on 7 and 8. We're going to defer action on that until the next scheduled hearing, which is in July 2021, somewhere in Colorado.
It is, it's in Denver and back.
Okay. Be good to be back in Colorado. I will regret that. Okay, you understand the motion? Any further discussion? Hearing none. All those in favor indicate by saying aye.
Aye.
Opposed, same sign. Motion carries. Thank you all very much for your excellent presentations. I believe that concludes most of what we intend to do today, with the exception of an executive session.
My understanding is that we're not taking up executive session and that if it's your pleasure, we could adjourn.
Yeah, I just wanted to let the listening public that no executive session occurred today at lunchtime, and we're going to
Okay.
take it up next time.
You heard that from our council, that no executive session occurred at the lunch break. We have taken none today. We'll do that another time, and we will officially adjourn. Thank you all very much.
So there's nothing